I'm not going to touch this part about the supply chain management, as our two gentlemen have talked very widely, and they have covered up the entire scope, right? So let me go into the more detailed aspect, in more practical aspect, when it comes to a company or a country, when there has been a disruption. So in this disruption, we have, coming back even like in India, where, the workers don't want to collect onion because they fear that, they're going to collect onion, it's going to affect them and they will get the virus. So this totally affected the export of onion to other countries. So let's come back here. So the legal rights and obligation of disruptive of supply chain management, of course, when come back, the legal rights and contract of each jurisdiction. The law of Malaysia could be unlike the law of India, could be more like with England, but will not be similar with Saudi Arabia. So it also depends where the contract is signed. In some instances, when the contract is signed, let's say in China, the law applies in China. We cannot apply the Malaysian contract in China. Likewise, if the contract is signed in Malaysia, it applies in Malaysia. So it all depends which jurisdiction is being signed. Then, of course, we have to look in the terms of the contract. The terms of the contract will be classified as condition and warranty. The word condition is the main aspect of the contract. If the supplier or the country or the manufacturer fail to supply the goods in time, so what is the course of action? The course of action is to terminate the contract. But in a situation like COVID-19, can we terminate the contract? That's the issue. That will come later. So this China, of course, they have their own law, right? And as you know, most of the goods are coming from China. So we have the remedies available for each country's known as force majeure clause. The first measure is known as the act of God. It's a French word, right? It's not a Latin word or English word. It is a French word, right? So it's due to the non-performance under the contract. So can a party terminate the contract? So COVID-19, as for instance, like China, we should of course face China. You know why? They're very successful in containing the disease, all right? And today there's no second surge as in compared to America or even compared to India. So the surge is increasing day by day. It's very frightening. But China is able to contain this COVID-19. They're very successful. And you can see them, they're even exporting the goods globally. They become one of the main supplier, right? So there are, of course, certain standards to be followed to use this major clause. So most contracts will be devised by lawyers of international lawyers, who are lawyers in that field, to include the force majeure clause is to protect them in case of any eventuality, right? Here I use the word any eventuality. It could be a disease, it could be a catastrophe, it could be a destruction, or even could be a what we call geopolitics, all right? Now we also come across with most of geopolitics in South China Sea. We're coming across, all right? And this would also affect the relationship of each countries, and that's going to affect that country, and that are going to affect the supply of the goods in other country. In that circumstances, can we use the force majeure clause? So the court would ask, to what extent you have been affected by the inability to supply. If the inability to supply is just for a short period of time, then the thing will be allowed. I mean, there will be some reasonable, the reasonable ground to allow the extension of the time, and so when everything is recovered, then you can supply the goods. But then the law says that you have to mitigate. The company is supposed to produce goods, or let's say like Vietnam is supposed to supply rice, but they simply terminate the contract. Of course, Malaysia may have the cost of legal action against Korea, against Vietnam for not supplying the rice, because they have to mitigate. Mitigate the sense means they have to look for alternative country to supply the rice. Failing which, they simply terminate the contract, putting Malaysia into jeopardy, into a very difficult position, and have to look for the alternative supply. So of course, in matter of time, there will be some discussion at the political level, and probably they will get some compensation. Okay, coming back to China, what they did was, they issued a certificate during the month of January to March, where China was not able to supply the goods globally. So what they did was they issued the certificate of major clause, giving the protection to the particular company. So that the international other global countries, they said this is very unfair. If you're going to protect your particular company, is that the other part, the recipients, is in jeopardy. So they cannot take any cause of action against China. So only protect that certificate, only protection of that particular company in China. But then eventually there was some discussion, so they have begged it not to issue the certificate at the moment, right? So can the contract be frustrated if the COVID-19 extends for a period of 1 year? Yes. A period of 1 year, then the contracts becomes frustrated. The word frustration is of course came from English law. The contract is incapable of performance. That means, I give a good example of the word frustration here is that an earthquake has occurred, the building has collapsed. So it is impossible for the developer to redo the building. Then the law came back again in UK. The contracts become radically different. It means totally different to perform the contract. So the contract becomes frustrated. In that respect, the contract has been frustrated if in that case a country has signed the contract. Let's say Malaysia signed a contract with another company in China to supply, let's say, all the computer components, all right? And the factory in China has burned down, all right? So, of course, the contract is terminated. So what the law says, the English law says that you have to pay for the cost of the materials being produced, not for the total cost. So in that company, only have to pay for the cost, nothing much. So the contract comes to an end. But coming back to COVID-19, can a frustration could be applied? No. COVID-19 doesn't last very long. And only it looks like USA has been extending too long, right? It's unbelievable. It become one of the topmost country, its highest number of cases today in US, right? And now has already got to these young children. But of course, no other sectors have been affected to make the contract become frustrated. So the only thing is that they can use the force majeure clause, right? They call it the act of God, to allow the company to come back. Just like, in Ohio in America is a very famous place in the US, there are a lot of meat. So that one of the workers in the US, in Ohio, was got a COVID-19, and the whole plant was put into hold, and they sanitized the whole area, and then to put, 14 days for them to rehabilitate, and after that, after the clearance and sanitization, then they start production. So that is applicable. But another good example is that China has terminated a contract with Australia. Where Australia was the largest supplier of meat to China, but because of some political reasons, China has terminated, and that is, it doesn't come under these force majeure clause. It comes on the issue on political matters. All right, it's not to be discussed here at the moment, but just to give you some what is happening globally at the moment. Then coming back to the force majeure clause, in Saudi Arabia, they have in Middle East, they have has been codified, those are the hardship events based on Sharia law. So most Islamic countries, they have the Sharia law. They may not incorporate the British law or the common law, and they include those hardship events, which is quite alike, very similar to this major clause. So it says that a specific consideration to the relevant code is required. For example, Article 249 of UAE Civil Transaction Law and Article 171 of the Qatari Civil Code. So it is similar like force majeure clause.
Dr. Gandhan, I'm sorry to interrupt. Because due to the time constraint, is it possible for you to go to the conclusion on your presentations?
Okay. Just give me just 15 minutes. Okay. All right. And also, just to brief out is that so one of the consequences of this COVID-19 or this natural disaster, it may also lead to the financial uncertainty and insolvency. So the word insolvency means there's a possibility the company may go into a bankruptcy. So since because of time constraint, I couldn't proceed much, but I just elaborated on this frustration, the terms of contract, and the main part is the major clause, which is very practical at the present moment in any business transaction. Thank you so much.